love this popular movie called How to Succeed in Business Without Really Trying. So this story here is called How to Get Sued Without Really Trying. In today's video, we discuss how a distributor of a health and wellness consumer product, it could be you, they brought themselves a lawsuit when they purchased an FDA-registered Class 1 medical device and promoted it on their website. What happened in the nutshell is that the manufacturer represented to the distributor, the buyer of the product, that the medical device was a Class 2 medical device and had FDA clearance pursuant to a 510(k). Now, that all sounds great. The problem is that after selling the product successfully for a year, the distributor got sued. And it turns out that one of their customers hired a lawyer who found out that the product really hadn't been FDA cleared. There was no 510(k) supporting an FDA determination of substantial equivalence, and it wasn't Class 1 either. So if that sounds like a lot of jargon, remember that if a medical device is 510(k) exempt, then you don't need FDA clearance, but you do need to register as a medical device establishment, and you do need to list your product with FDA. If a medical device is not FDA exempt, then you have to establish that your medical device is substantially equivalent to what's called a predicate device, and you have to get FDA clearance under a 510(k) submission. The problem here is that the buyer just didn't do their due diligence on the seller's representation that the medical device had FDA clearance. Now, if the buyer billed commercial insurance or Medicare for using the device, then the plaintiff could possibly add insurance fraud to the list of their claims, and on top of that, false advertising. And there might be federal statutes involved that provide for criminal penalties. Anyway, it's all very dangerous territory for an innocent mistake or possibly an oversight. I'm Michael H. Cohen, founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients navigate healthcare and FDA legal issues and launch or successfully grow their health and wellness product or service. And the little glitch that I just talked about is simply one example of many ways that a company can get in trouble for false advertising. A lot of healthcare practices and companies believe all of the claims made by the person who sold them a healthcare product. And this has happened, multiple times. We've seen it. I mean, sure, it's easy to get revenue from buying a product. Yes, it's supposedly FDA cleared, registered, listed, approved. And if you believe that, I'll throw in the Brooklyn Bridge on top of the sale item. So the point is that you got to be very careful when you buy something or just redistribute it. And the law is whenever you sell a health and wellness product, you are responsible to ensure that every claim you made for the product is truthful and not misleading. And this includes claims about FDA classification of the product. And further, all claims must be substantiated. And if you claim that your product is superior to another similar product on the market, that claim too must be substantiated or supported by a high level of evidence as well. There are lots and lots of takeaways here, and I guess I'll make them on the video. So whenever you put a healthcare product on the market, have legal counsel review all of your marketing collateral for potential false advertising exposure. Number two, if you think you're safe because the person who sold it or is selling you those products is making certain claims to you, you're not safe. Don't trust the claims. You have to figure out for yourself whether any particular claim is potentially unsubstantiated, problematic, and thus could get you in legal trouble with FTC, private plaintiffs, lots of people. And three, remember, again, your exposure at least double. Once to the Federal Trade Commission or FTC, once to a private plaintiff. Private plaintiffs are watching, and they hire lawyers and law firms to comb the internet for potential violations they can go after. So even if the government doesn't catch you, another lawyer could. Well, thanks for watching. I hope you enjoyed those recommendations. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact. We'd love to hear from you. Send us a message or book an appointment. Here's to the success of your healthcare venture. I know we've given you the bad news. The good news is we love what our clients are doing. We love working with people, and we look forward to speaking with you soon.